Okay, so in this lecture, I'm going to be talking about the concept of authorship under the Copyright Act and why it matters. So under the Copyright Act, the copyright in a work of authorship initially vests or initially belongs to the author or authors of the work in question. So authorship matters because the initial copyright owner of a work of authorship is by definition the author or authors of the work in question. In other words, authorship is critical to the creation of, of copyright ownership. But it also goes to the question of who counts as an author of a work. In other words, what do we mean by authorship? How do we define authorship? Who can claim authorship? And what's the subject matter of authorship? So obviously, when it comes to a lot of different kinds of works, they're made by a bunch of different people, right? So many people participate in the creation of a work of authorship. The question is, who counts as an author? So there's a really great illustration of this problem in the case Aalmuhammed v. Lee, which involved the creation of the film Malcolm X. And essentially, who could be an author or who was an author of the movie? So this is a major motion picture starring Denzel Washington, a biopic of the iconic civil rights leader Malcolm X, directed by Spike Lee, right? But controlled by a movie studio, right? And so the question is, who can be an author of this work? Who is an author of the work under the Copyright Act? So Jeffrey Aalmuhammed was a member of the Nation of Islam, a documentary filmmaker in his own right, and someone connected with Denzel Washington, the star of the movie, who provided advice throughout the production of the film at Denzel Washington's request and expense about, how to perform the role more effectively and how to make the movie truer to life, as it were. Right. So Jeffrey Aalmuhammed spends the production of the film at various points providing advice to Denzel Washington. The film concludes, and there's an effort to sort of cash out his contribution. And he is not willing to accept the offer he receives from the movie studio, right? Essentially, he argues that based on his contribution to the movie, he is an author of the movie and therefore entitled to some degree of copyright ownership based on his contribution to the film. And so the question fundamentally presented to the court, at least as the court conceives it, is Jeffrey Aalmuhammed an author of the movie based on the facts presented in this case? And it ultimately decides that he isn't. And the reason is somewhat interesting, right? Or the reason is kind of the fundamental problem or kind of problem presented to the court in this case. Essentially, Jeffrey Aalmuhammed says, look, copyrightable subject matter is the contribution of any original element. I contributed a bunch of original elements to the movie. Kind of reading between the lines, those individual elements may or may not have been individually copyrightable. But in the aggregate, if you put them all together and think about their relationship to the other, I contributed a lot to this movie, and that's enough to satisfy the low bar for originality. And the court ultimately says, no, right? That when it comes to a work of authorship, we're only going to find authorship of a work as a whole when it comes to kind of the prime mover of the work, as it were. In other words, whoever is sort of the mastermind or the person who's responsible for the creation of the work, that's the author, that's the copyright owner, not people who contribute ancillary elements. Jeffrey Aalmuhammed wasn't the primary creator of the work. Therefore, Jeffrey Aalmuhammed isn't an author of the work either. So note the tension between the concept of copyrightable subject matter and how the Ninth Circuit is conceptualizing the authorship of a work in this particular case. I mean, after all, if Jeffrey Aalmuhammed has contributed a original copyrightable element to the work, how can he be denied authorship of that original element he contributed? And if you can't separate that original element from the work as a whole, how is it that he isn't an author of the work at the same time? Okay, so example I like to give to sort of think about this problem is the Oscar Selfie taken in 2014 at the behest of Ellen DeGeneres, right? So a bunch of celebrities were at the Oscars, and Ellen DeGeneres had the genius idea of getting everyone together to get a selfie. It was very widely shared, extremely popular, the most widely shared photo of the week or whatever it was on Twitter. Some of the people in the photo no longer ones who are currently celebrities, nevertheless, right? A really popular photo and one that did quite well. It turns out, however, that Ellen did not actually take the photograph herself, but rather gave her cell phone to Bradley Cooper, who snapped the photo. So the question then becomes, who's an author of the photo? Why are they an author of the photo? And how should we conceptualize authorship in this context? In other words, like, what makes you an author? How do we think about originality? And how should we think about sort of shared responsibility for the creation of a work under these circumstances? So maybe spend a moment reflecting on who might have a legitimate authorship claim under the circumstances. Okay, another really interesting case is the Urantia Foundation v. Maaherra case. So what happened here? In the 1930s, 1940s, a group of people in Chicago, led by a couple of doctors, discovered that a particular anonymous individual, businessman apparently, when he fell into a trance state, was able to communicate with supernatural beings. And they subsequently learned that by posing questions to this man while he was in a trance state, they could receive answers from the supernatural beings. And so they collectively formulated answers, which were then posed to the man, and who provided channeled answers from the supernatural beings. And these collected answers were subsequently collected into what became published and known as the Urantia book, which was the founding text of a religious movement. Well, Kristen Maaherra was an adherent of the Urantian religion and produced her own electronic version of the Urantia book, which consisted of the text of the book along with her kind of personal gloss on its meaning. So she, talked about various things relating to the book, including her own interpretations. And the Urantia Foundation brought a copyright infringement action against her, arguing that the Urantia book was a copyrighted work of authorship, Maaherra's response was, well, according to you and to the Urantia book itself, this is a text dictated by supernatural beings conveyed through a person in a trance and merely transcribed by the people who are the members of the Urantia Foundation. If, according to their own telling, they didn't contribute any original elements, then they can't be the authors of the work. And in order to claim to be authors of the work, they would have to disclaim the supernatural origins of the book itself. Well, the court kind of sidestepped this entire problem by saying, well, that may or may not be true, but the Urantia book is not merely a transcription of the observations from the supernatural beings, but is in effect a edited compilation of the observations, and therefore the Urantia Foundation can claim ownership of the edited compilation, even though it may or may not, presumably may not, be able to claim ownership of the underlying composition itself, which was authored by supernatural beings who may or may not be copyright owners or authors for the purpose of the Copyright Act, but at the very least aren't the Urantia Foundation. So, you know, if someone's the author, then they at least aren't the authors themselves. Concern here, of course, is whether Maaherra necessarily copied the original elements added by the Urantia Foundation, which the court does not explicitly address, right? So, I mean, even if we accept that the Urantia Foundation added original elements to uncopyrightable underlying subject matter, the question still remains, were those original elements actually copied? Okay. So Garcia v. Google, another really interesting and controversial recent case in which a woman was essentially hoodwinked into appearing in a quote unquote documentary, which, you know, she didn't understand the nature of the film she was appearing in, and in fact spoke lines in the movie which are then dubbed over to make her say essentially things that were offensive to Muslim people. And the movie in which she appeared was released as a YouTube film titled Innocence of Muslims, which was, again, quite offensive and said a number of scurrilous things about Muslim people, and was relevant to the subject of the litigation, the source of considerable discontent with Ms. Garcia, the subject of the movie. And so essentially she claimed copyright ownership in her performance in the movie and requested or insisted on the removal of her performance and or the removal of the film from YouTube. YouTube declined. A panel on the Ninth Circuit decided in a kind of narrow decision that, or kind of closely decided decision really, that she could make this claim that she had contributed an original element by performing in the movie. And the Ninth Circuit took the case on bank and ultimately reversed, holding that she was not an author for the purpose of the Copyright Act, kind of leaning on Aalmuhammed considerably, but also on policy concerns. And Spirited Defense arguing that Garcia ought to be entitled to a copyright claim in her performance. However, one that didn't necessarily wrestle with what that would mean in practice. And so, you know, maybe reflect on the question, you know, if the dissent here were correct, what would that mean for, say, documentary film or for example, reality television, right? Where people might appear in a movie without being previously contracted to appear in the film, right? I mean, is it really the case that anytime someone appears in a work of authorship without without signing an agreement in advance, they are a joint author and therefore a co-author of the work in question? Is that a workable rule? Does that make sense? You know, how should we think about authorship under these circumstances? Does it make sense to think about appearing in a motion picture as being a sufficient indicia of authorship? Okay, and then finally, in Naruto v. Slater, otherwise known as the monkey selfie case, what happened was a photographer by the name of Slater traveled to take photographs of crested macaques. And while he was engaged in his photographic enterprise, one of the monkeys he was photographing picked up his camera and started fooling around with it and succeeded in taking pictures of itself, one of which, the photo on the right, became widely distributed as the so-called monkey selfie photo. So Slater claimed ownership of the photo. His claim was disputed by Wikipedia, among others, on the grounds that non-human animals can't be copyright owners. And so there was a kind of an ongoing dispute around Slater's ownership. And then PETA, People for the Ethical Treatment of Animals, stepped in purporting to act as the next friend of the monkey, right? So they at least claim to identify the monkey as one named Naruto, and argued that Naruto was in fact the copyright owner, and that they were pursuing Naruto's claim to own the copyright and to be in a position to control ownership. Obviously, the court was having none of it and rejected PETA's claim on the ground that, irrespective of whether it's possible for non-human animals to be copyright owners, that was not the intention of Congress in drafting the Copyright Act, and therefore copyright did not extend to Naruto under the circumstances. But again, it goes to the question of, what do we mean by copyright ownership? What's the indicia of copyright ownership? What constitutes the kind of metaphysical basis for copyright ownership, and why, after all, Naruto hit the button, does that make Naruto the creator of the photograph or not?